Good morning, everybody, and thank you for joining us for our webinar today with Sean Tierney from the Corporate Enforcement Authority. I'm Dee Moran and I'm the Head of Professional Accounting here in Chartered Accountants Ireland, and we look after the technical guidance for members. I think this is a really important topic, as we certainly get many questions from members who've been asked to join a board, a lot of the time for a not-for-profit company. But likewise, it may be for a family company or as a non-exec in a private or public company. But, I think the duties and the responsibilities are onerous for all of them. And, our advice is that you need to understand what you are signing up to, and to understand the risks with it. So what better person to talk us through this than Sean Tierney, Senior Forensic Accountant with the Corporate Enforcement Authority, a role which Sean has held since 2021. Sean holds a Bachelor of Business from Trinity College Dublin, and he is a fellow chartered accountant, having qualified in '92, and he also has an advanced diploma in corporate white collar and regulatory crime from King's Inns. And prior to joining the CEA, Sean worked for over 30 years in the private sector, engaged for the most part in insolvency and restructuring. So good morning, Sean.
Morning.
We really look forward to hearing from you. So without further ado, over to you, and we will have a Q&A after your presentation. Thank you.
Thank you very much. So as outlined in the introduction there, I'm a forensic accountant with the Corporate Enforcement Authority. And the talk today is basically to give you a brief outline on the work that we do, and more importantly, the duties of directors. And I suppose the central idea that we want to get across to yourselves is that there is no idea of director light. Every director has the same duties and responsibilities, no matter what type of company you're running or no matter what type of position you're holding as a director in that company. Just briefly, the company's legislation in place in the country is the Companies Act of 2014, which replaced numerous acts which had been passed in companies legislation running from 1963 onwards. And it updated that legislation. If you think in 1963, I believe there was something like 8,000 companies in the country, and now we have 300,000 approximately. So things have changed drastically since then, and the Companies Act had been updated to take account of that effect. Largest piece of legislation passed in the history of the state, and it's covering the whole life cycle of the company from inception to dissolution. The Companies Act provide that a company has a separate legal entity, and this is important in that it can facilitate continuity. It doesn't matter who the shareholders or who the directors of the company are. It can continue to exist between various owners and so on. But more importantly, by having limited liability, it can encourage entrepreneurial activity. But with the limited liability come responsibilities. Directors are expected to operate within a certain legal framework, and there are transparency requirements that must be complied with to protect the wider public, creditors, employees, shareholders, etc. There are criminal and civil sanctions that can be imposed in situations where directors or company have not complied with the requirements. So Corporate Enforcement Authority is the agency which has been tasked with upholding compliance with company law. Our role, obviously, to encourage that compliance, but in situations where there is non-compliance, to take appropriate enforcement action. The organization is a multidisciplinary organization. We have digital forensic people here, forensic accountants, members of the Garda Síochána, and solicitors and barristers. And as we said, our function is to encourage compliance with the Companies Acts. We investigate instances of non-compliance, and we take appropriate enforcement action on a graduated approach, encouraging compliance in situations where that compliance does not actually happen, that we could take civil action in the courts, or refer more serious indictable offences to the Director of Public Prosecutions. Our sources of work, we receive public complaints from interest groups, public representatives or whistleblowers. There are a number of reports, mandatory statutory reports that must be submitted to us. For instance, an auditor, if they discover that previous sets of accounts contained errors and didn't show true and fair view, they must send us a report. Also, liquidators, every liquidation, we get a report on the conduct of the directors. We also get reports from other regulatory bodies, such as IASA, the Central Bank, the Companies Registration Office. And we can commence investigations on our own initiative. We become aware of situations where there may be non-compliance with the Companies Act. I've mentioned this, but we have a graduated approach to enforcement. Administration measures would be where we believe that a dialogue with the company will encourage them to put whatever they are doing wrong right. This would be in situations where the offence or potential offence would not be on the serious end of the scale, and simply a word in their ear, and they may make themselves compliant again. We can also take civil enforcement proceedings. This will be in the district courts or the high courts, where we can get orders to make directors comply with their requirements. On more serious matters, there'll be criminal enforcement procedures will be taken. Summary prosecution by ourselves, but in more serious matters, we would submit a file to the Director of Public Prosecutions for consideration of whether they should charge people on indictments, and charges on indictments carry much more serious penalties than a summary prosecution. We have certain statutory powers within the organisation that we can invoke without recourse to the courts. We can require the production of minutes, directors' minutes, or general meetings of the company, annual general meetings, etc. We can require the production of company's records, so books and records of the company, books and records of the receiver, books and records of liquidators. Upon application to the court, there are further powers that we would have. That would be to appoint an inspector to review the affairs of the company, to order the inspection of books and records of the company in liquidation, and we can apply for search warrants. As I mentioned, the guards, we have guards that are seconded to the authority here, and they would have the powers to apply to court to detain suspects and to seek production orders following completion of an investigation. The authority can prosecute in its own name, or with more serious matters, refer to the Director of Public Prosecutions. And we do make the point here that many of our investigations that we would carry out would identify other breaches of legislation, so it would not be, uncommon to commence an investigation and discover that there were taxation offences or theft or fraud offences haven't taken place. We mentioned the case study there, and you may be aware of this one that happened last year. Pastor of a church, an investigation had commenced, and we discovered various acts of theft, fraud, deception. We prosecuted in the courts, and Mr. Dundon was convicted of 9 company law offences, 73 counts of theft, and 5 counts of deception. And he was actually imprisoned for 7 years based on that conviction. Little chart there that just shows you the different categories of offence. Category 1 being the most serious offence and carrying the most serious of penalties. And as you can see, the summary conviction versus conviction and indictments. Indictment carries much more serious of penalties. So that's ourselves, just to deal now with directors and directors' responsibilities, and this is what we are trying to promote here. A director would be someone who's appointed, usually by the shareholders, members of a company, to manage and run the company on their behalf. Essentially, anyone over 18 can become a company director unless they're non-discharged, bankrupt, or they have been disqualified or restricted by orders of the court. I think this is the most important slide in the whole lot, and it's just to stress that all directors have the same legal responsibilities, and they will share the responsibilities. So you may be calling yourself a non-executive director, you still have the same responsibilities as someone who puts themselves forward as the managing director. So different classes of directors, but no matter what you call yourself, you still have the same responsibilities as your fellow directors in running a company. The last 2 types of directors mentioned on the list there, a de facto director would be a director who, while not appointed, essentially is running the company and acts as he is in his day-to-day dealings. And a shadow director would be somebody who hasn't been appointed but is behind the scenes and directing an individual or other individuals as to how to act as a director. As I said, they're not formal appointments and would normally be made as a decision of fact by a court should, a party be seeking redress. Companies' duties, they come under 2 headings: fiduciary duties and statutory duties. So the fiduciary duties had been laid down in common law for many years. The essential point to note about fiduciary duties is that you as a director must act for the benefit of the company. So you put the company's interests before your own interests or anybody else's interests. So we've listed what's generally been considered fiduciary duties there: to act in good faith, to act honestly and responsibly in accordance with the company's constitution, not to be using the company's property for your own benefits, to avoid any conflict between your interests and your duties to the company and any other interests that you may have. Important point: to exercise the care, skill, and diligence which would be reasonably expected of a person in the same position with similar knowledge. So, in other words, you're not expected to have, very detailed technical experience, but the experience that you do have must be used for the benefit of the company. And again, to have regard to the interests of the employees and the members as a whole. The statutory duties as laid out in the Companies Acts, to disclose to the company certain personal information and any interests that you may have in a contract or a proposed contract. Very important to keep adequate accounting records and to prepare financial statements based on those records, to have those financial statements audited, to maintain certain registers, convene meetings in the company, and to file certain documents with the Register of Companies. The duty to maintain adequate accounting records. The failure to maintain these records would be a Category 1 or 2 company's offence. Adequate records should correctly record and explain the transactions of the company and enable the assets, liabilities, financial position, the profit and loss of the company to be determined with reasonable accuracy at any time. To give a true and fair view of the affairs of the company, to ensure the accounts comply with the Companies Acts, and enable those accounts to be properly audited. So financial statements should be prepared, obviously, on foot of those books and records. Those financial statements, again, should provide a true and fair view of the assets and liabilities of the company, the financial position of the company as at the year end. Directors should not approve financial statements unless they're satisfied that they give a true and fair view. The default position for financial statements, and obviously these are amended by way of, whether it's a small company or a micro company, but the default position is that, financial statements should include profit and loss, balance sheet, cash flow, notes as to the accounting policies, notes to the financial statements, and the director's report. The financial statement should be audited unless there's an audit exemption. We know what an audit is. An audit is an independent examination of the financial statements by an independent professional. The auditor is obliged to report to the members of the company and should provide an opinion as to whether the financial statements give a true and fair view and if they're in agreement with the accounting records of the company. Obviously, a director can qualify their opinions, but you're in a company, if you're running a company and you've got a qualified audit opinion, it does have consequences regarding your dealings with banks and so on. The directors are obliged to maintain certain registers and other documents: a register of members, beneficial ownership, register of the directors and secretary of the company and their interests, register of debenture holders, i.e. any mortgages and so on the company's property, minute books, director service contracts, and any contracts to purchase its own shares. The directors of the company have a duty to file documents with the Register of Companies. The most common one being the annual return. There are, in our case studies, we've mentioned a number of cases that came up recently where annual returns weren't filed and how we have dealt with them. And again, you would see if you look at those case studies, you can see how we have used what we call a graduated approach to encourage compliance in these situations where we engaged with the company and pointed out where their filing requirements haven't been fulfilled. Those companies actually then went and ensured that they were up to date. One of the case study 6 refers to a charity, and again would just to emphasize that, be it a charity, be it a non-profit organization, be it a ordinary trading company, your filing obligations remain the same across the board. Directors should file any change in the annual return, any change in the registered office, or changes in directors and secretaries, any alteration to the share capital, the creation of any charge. If a director has become disqualified abroad, this should be filed with the company's office, and any resolutions passed by the company. General meetings of the company, there's an obligation on the company to convene these general meetings, an obligation on the directors to convene these general meetings. Maximum of 15 months between each general meeting. Notice should be given to the members of the company, and this is usually 21 days notice. Meetings usually are held within the state, but there are certain exceptions. At that AGM, the directors are required to place the company's audited financial statements and to have them approved. The director's report must be annexed to those financial statements. One of the issues that has arisen quite a bit, but less so now, and that I think companies are becoming more aware of this, is a restriction on loans to connected parties. So a company providing a loan to a director or members of that director's family. The general rule is that they're not allowed. You're not allowed to provide a loan. You're not allowed to provide guarantees for a loan. And there are exceptions where the amount of the loan is relatively small, so less than 10% of the relevant assets, basically the net assets of the company, where the summary approval procedures have been followed. If the loans between group companies, or reimbursement of expenses, or if the business of the company is actually to provide loans. In a situation where you have a company that is insolvent or is on the verge of insolvency, directors have a heightened degree of responsibility, and essentially their responsibilities are essentially is not to make the situation any worse. So you must have regard to the interests of the creditors, the need to take steps to involve insolvency. That is, if you believe that company could be recovered, and to avoid any negligent conduct that threatens the viability of the company. Liquidations, there's a number of different types of liquidations. We've got a members voluntary. This is a situation where you've got a solvent company. All creditors are going to be paid. shareholders, members of the company, potentially will get a dividend at the end of the day. Or, sorry, share and distribution at the end of the day. Creditors' voluntary liquidation is a situation where you've got an insolvent company and the directors of the company themselves convene a creditors' meeting to appoint the liquidator. You can have a court-ordered liquidation where either creditors or the company itself applies to the court to have a liquidator appointed. In all scenarios, their directors have a duty to cooperate with the liquidator, to cooperate with the Corporate Enforcement Authority if so requested, and to provide full information as to the affairs of the company. A director of a company can be held personally liable if found liable for reckless or fraudulent trading. Is very important, and why companies that potentially may fall into insolvency, why the directors of the company should be very careful in how they deal with those affairs of the company in the run-up to insolvency. Directors can be restricted or disqualified. The authority, ourselves, we could make an application for the restriction of a director who was a director of an insolvent company, or an insolvent company who'd failed to convene a general meeting of the shareholders to actually appoint a liquidator, or a company who basically has closed the doors, even though it's insolvent, has closed the doors, not appointed a liquidator in the hope that the company would be struck off the register of companies. Restricted directors can continue to act as a director of the company, of a company, but only under certain conditions. For a PLC, there must be a minimum share capital of 500,000. For all other companies, a minimum share capital, paid up share capital of 100,000. Restriction is generally for a period of 5 years. We do have a situation where we can ask the director to voluntarily accept a restriction. This avoids the necessity to go to courts, saving money on each side. Disqualification would be in situations of more serious offences committed by the directors. And the disqualification, as the name suggests, means that you may not act as a director of the company under any circumstances. If you are convicted on indictment of any offence under the Companies Act, or fraud or dishonesty, you are automatically disqualified. Well, we mentioned a couple of case studies there. The NAGP reference is to the National Association of General Practitioners. Was in the news relatively recently. One of the directors was fined 10,000 and was disqualified from acting as a director of the company. This is in a situation where we had argued that the accounting obligations of the company were not being properly fulfilled. The other case study mentioned is Thomas Colton, and this chap was disqualified as a director, but continued to act as a director in another company, and he was found guilty of an offence, and we are awaiting sentencing for that individual. Sorry, that's the end of my talk. I will say our website does have a number of very useful booklets. duty of the directors, and we'll also provide information regarding the penalties that are available to be imposed under the Companies Act. I'm sorry, that's the end of me.
Excellent, Sean. That was that was excellent. There really is a huge amount in there. And again, just coming back to what we said at the start, I think it's all really relevant. And for anybody who is looking to be a director, this is important. And I think you mentioned it there on the slide, but you know, one of the big things that just really resonated with me was that all directors have the same legal responsibilities, and I think that's a really important point. And I suppose I know like a lot of our queries will say would come from members and others who have asked to go on the board of a charity, for example, and sometimes like all charities, I guess they will tend to try and bring somebody in who's a bit of expertise in IT or HR or finance or whatever. And I guess it's just that they kind of understand, even if they go in with their HR expertise, that they actually still have the same responsibilities. So I guess just on that, like if you are a director, if you're asked to be a director of a charity, are you expected you are expected to follow the same duties even though you are a volunteer, aren't you?
Yes, indeed, and that's the important thing to get across. That once you become a director, once you sign up as a director, you're taking on the same responsibilities as every other director of that company.
Yeah,
And if requirements are not being complied with, you can't say, sorry, I was a non-executive director, or I was only responsible for, IT or whatever.
yeah,
You were director of the company, full stop.
yeah, yeah, yeah. No, that's that's very good. Um, just another question in here. Are all company directors who are found to be in breach of company law, are they all convicted, or are there various levels?
But this is again, this is what the point that we had made earlier in the presentation, is that we try to take a graduated approach. And the graduated approach, we find that in the vast majority of cases, when a company becomes aware that they are in breach of their statutory requirements to file in the company's office or whatever, once they become aware, or definitely once they become aware that we're aware of it, um, they the vast majority would tend to move and put themselves back in compliance. So the scenarios where we end up in the courts
Yeah,
would be more serious offences, and certainly cases where it doesn't look like the directors are going to put the company back into compliance and require orders from the courts, or require penalties to be imposed.
sure. So I suppose it's fair to say that most people will obviously want to try and get the company back in compliance. That it's really a very small cohort that you would see
That's that's what we find.
going
Yes.
to
Yeah.
court. Yeah. Okay.
I mean, some of the penalties can be serious enough,
Sure.
and you don't want, certainly if you're in other lines of business, the last thing you'd want would be, a restriction order against you, or disqualification, because it could have very
Absolutely.
serious effects in other aspects of your life.
Absolutely. Yeah. Um, just a question in here. Do you tend to come across shadow directors much in your work? And in any that you would, what kind of context would you see those in?
We, again, a shadow director would be, I suppose it's a movable feast. So you could have a set of facts and decide, well, this guy here is a shadow director or potentially is a shadow director. But essentially, it's if proceedings are taken in court, it would be found as a fact by the courts. This guy is a shadow director or isn't a shadow director. So there's no hard and fast rules to say who is and who isn't. To a large extent, it's up to a judge on the day examining the facts and making the decision as to what he believes those facts imply. You do get quite a lot of people suggesting that others are shadow directors. As I said, it's not something that you can make a decision on, but it is something that you would bear in mind, and if you're carrying out an investigation, that potentially that there is a chap in the background that may be in the crosshairs in the future should proceedings be taken. In that scenario, you would have to lay out a case to the courts as to why you believe that individual is a shadow director.
Okay, yeah, no, that makes sense. When a company is a virtual registered office, where are the requirement documents? I mean, all companies, as far as I know, would have a physical address.
A physical address, absolutely. It may be that the address might be provided by a secretarial service. The requirements for where you locate your books and records, that was the question, isn't it?
Yes.
So the Companies Act mentions the registered office of the company, but it also allows the company to decide where is the best location for those books and records to be kept. So it could be kept at the place of business, or it could be kept at some other location. But the Companies Act does give the company the flexibility to decide where the most appropriate place for books and records.
Okay, great. Thank you. There's one in here on your booklet. Is the booklet from CEO and company directors free that can be distributed to clients?
Yes,
yes,
it is, and it's available you can download it off the site. So
yeah.
yes, it is.
And I have to say, it's a really excellent booklet for anybody who is looking to or has been asked to go on a board. It's definitely a booklet worth
Yes.
looking at. And likewise, Sean has mentioned the case studies. The case studies are within the annual report. The report for 23-24 was out, I think, last September, Sean, maybe, but there's about, I think, 15 case studies in there of cases of live actual cases, and I think they're really interesting, and I think they just give a really good sense of in cases where companies came under the CEA, what happened on them. So I think they are really, really well worth looking at. Just see what other questions are here. What are the types of companies, Sean, that do not hold AGMs?
The only one I can think of would be a single member company where, they it's very difficult to hold a meeting with yourself. So, the legislation actually acknowledged that eventually. That would be the only. Every other company is required to hold an annual general meeting.
Yeah.
So
Okay. Great. There's just one in here on managing companies. So what is the authority's experience of apartment managing companies? So these are obviously ones that are in place to manage the apartment block, and just are volunteer directors doing their jobs, or what kind of issues arise for
Yeah.
these companies? So not
Well,
sure if you've had much experience of
we'll
these.
start off with the comment that no matter, like every other type of company in the country, the compliance is generally pretty good. It's only the small minority of cases that you would come across where there isn't, where compliance isn't uh, being properly done. So we do, and we have received a number of reports and complaints in here of property management companies that aren't holding annual general meetings, that aren't filing their returns with the company's office, or that hold meetings but may not have provided the proper notice to the members to attend. And the members feel that their rights are being restricted in that situation where they don't get the chance to speak at an annual meeting, annual general meeting. So yes, we do get reports on those. Like I said, again, it would be a minority of these type of companies, but again, we do get involved in ensuring compliance where we become aware of these companies. And that's, again, through our graduated approach, we would find that most of these companies would bring themselves up to date and in compliance once they have been contacted by ourselves and encouraged to do so.
Okay. Yeah. And I assume again, if you are looking to to join one of these boards, that it's obviously important to understand who else is actually on that board and what their expertise is, and
Mm-hmm.
that there is at least one or more people who are well versed in
Yes.
ensuring that AGMs are held,
Yeah.
etc., etc. Yeah.
Yeah.
Okay. Um, Another one in here. Do the same rules apply to trustees of an unincorporated charity such as a school?
No, if you're not incorporated, the Companies Act doesn't apply. So yeah, there would be, outside my field of expertise, but there would be various regulations by the charities regulatory body. Don't even know the name off the top of my head. But Companies Acts don't apply, and if you're not incorporated.
Yeah. Okay. Thank you. Um, so this is one, and it's probably one that we would see, or a version of this we would see a little bit. My company has asked me to be a director of a company. I'm not involved in the day-to-day operations. They've assured me that if any issues arise, I'll be indemnified via their D&O insurance should I seek further protection. So again, I think coming back to it, uh, everyone has the same legal
Yeah,
responsibilities, haven't they?
that's the first thing. You're talking about directors' insurance. That'll cover you in situations where an aggrieved party might sue you. Um, but if the company is not complying with the requirements of the Companies Act, you can have all the insurance that you want, but it's not gonna to get you out of those requirements. So you could end up being restricted or disqualified. Your insurance isn't going to cover you for that. You could end up with a fine imposed by the courts. Your insurance may or may not cover you for that. I don't know the ins and outs of every policy. You could end up with a custodial sentence, and your insurance isn't going to cover you for that.
Yeah, absolutely.
Yeah,
Yeah. Yeah, no, and I think that is really the whole point of it, isn't it?
yeah,
Um, Again. And this is probably a question that we would see, company director responsible for the preparation of financial statements has failed to prepare those financial statements for 3 years. What should the other directors of the company do?
But they're going to have to take on the responsibility and get it
Yeah,
done.
yeah,
You can't say, oh, well, Mr. X was the person, and because he didn't do it, my hands are clean. They're going to have to come up with some plan to get the financial statements prepared.
yeah. Okay.
It's a short answer.
Um,
That's it.
yeah, well, that's it. And I guess it all really comes back to the Companies Act and what your duties and responsibilities are really. Um, just a question here. So when would a potential case move from the CRO to the CEA office, as it were? So, for example, if you had outstanding returns with the CRO.
Yeah, there is communication uh, between the two of us, in that what you would generally find would be perhaps somebody would complain to the CRO, oh, look, company X hasn't filed for X number of years. And the CRO would pass that complaint on to ourselves. That would be the scenarios that you get, or someone would complain to the company's office that those set of accounts that have been filed, they've been filed on time, but there's a serious error in them, or there's a deliberate misleading statements in them. That would then get passed to us, and we would commence an investigation, perhaps on that basis.
Okay. No, that makes sense. Just one in here on, I guess, the duties and responsibilities of a company secretary. So, are these duties different from a director, for example? And, if meetings and that weren't held, have they the same duties and responsibilities?
Basically, yes. It's any officer of the company. Usually the Companies Acts would refer to, if any of, or if something hasn't been done, then any officer of the company can be found liable. So as a company secretary, yes, you are taking on the duties. Now there might be, which I haven't got any off the top of my head, but there might be certain circumstances where directors and secretary might have the different responsibilities, but most of the penalties do refer to any officer of the company.
Okay. And obviously, normally the company secretary would be very involved anyway in filing returns, making sure that everything happens in a timely manner,
Yeah,
etc.,
indeed.
etc.
Yeah.
Um, just a couple more here before we finish off. Um, this is one. So if books and records are kept at the accountant's office, for
Hmm.
example, what rights do you have to go into their offices with a warrant, or can the accountant's office, send you to a location where 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 they are? So I think this is just, saying, do you have to go into the office, or can they actually send you what you request?
Well, if it was the situation where we believe that we were going to get cooperation, um, we could ask for records to be sent to us, or copies of records to be sent to us. If it's a situation where potentially there might be criminal proceedings, we have to be very careful, because um, you have to show that evidence has been kept uh, at all stages of the investigation, that the original evidence has been kept intact. So if there were criminal proceedings being contemplated, you'd be more likely to go to get a search warrant and to take possession of the books and records. Basically, the guards to go and take possession of the books and records. so that they can maintain proper custody of those records.
That's fine. And just kind of tied in with that, I guess, is there a time period or limit that documents and books have to be produced on demand?
On demand, I don't believe the Act's actually set down limits. We would provide, if we were demanding records from companies' auditors or from directors of the company, we would normally look at what's reasonable. So you'd expect something to be turned around within, say, 3 weeks or 4 weeks or something like that. We would ask for that. If we felt that someone would need more time, we would generally give that more time so that the demand looks reasonable.
Okay. There's one in there on companies which are audit exempt. Well, audit exemption is based on turnover, really. So it is really smaller companies are exempt from audits.
Yes, provided they continue to file their returns on time.
The returns, absolutely.
And that's the big thing, is that if if the returns don't get filed on time, your audit exemption disappears. So, then all of a sudden you're back into paying an auditor to come in and do the job for you. So
you are.
Yeah.
Absolutely, and that has caught many companies, and as you know, we're just awaiting
Yes,
the part of the 2023 Act to come into force, which will give a one strike, I guess,
yes,
for
yeah.
loss of audit exemption. So I think certainly, I know a lot of our members will be very happy to see that in. Well, Sean, that was a really interesting and informative session. Many thanks, and hopefully it gives everybody a good sense of their duties and their responsibilities if they join a board. So we really appreciate you taking the time today, and again, just to say, there is lots of really interesting information on the CEA website, including that booklet that we talked about, and I definitely would urge you to have a look at the case studies in their annual report, which is also on the website. And thank you also to Chris from our AV team, who keeps everything going here in the background, and to everybody for joining us. We really appreciate it. So thank you and have a great day.
Thanks very much.
Thank
Thanks a
you.
lot.